Okay, so thank you very much for joining our breakout session. It is an honor for us to be here with you today to present together with Kate Kitahe from Men Engage Kenya Network, our latest case study titled Key Ingredients to Women's Legal Rights in Kenya. During this presentation, we'll give you an overview of the reform process and some lessons learned, main gaps in the legislation and in its implementation, and we will then conclude with an open discussion. Men Engage Kenya Network, MENKEN, is a national Kenyan NGO that engages men and boys in promoting gender equality by focusing on the prevention of gender-based violence, HIV, the promotion of sexual and reproductive health, positive fatherhood, and male engagement. Their objective is to improve the overall enabling environment for women's economic empowerment. As you have heard in the previous session, our project, Women, Business, and the Law, explores laws and regulations that empower or limit women during their working lives in 190 countries globally. We have also tracked reforms and changes over the past 50 years. As you know, we showed this slide in the previous session, but I think it's good to take a look at it again. You can see the progress in Kenya over the past 50 years. It is notable that a lot of the reforms that our indicators track have taken place in the last 20 years. And while this graph and this chart is useful information, it does only give a partial picture of reforms and why they happened. To gain a better understanding about why reforms took place and what lessons can be learned for future reforms, we embarked together with MENKEN on a series of interviews. We sat down with key stakeholders, international organizations, former members of parliament, drafters, and civil society organizations to learn what worked and what didn't in the legal reform process. During the next few minutes, we'll present what we specifically learned from these interviews, and we'll touch on, or we'll use the adoption of 3 landmark laws in the areas of violence against women and employment to highlight some of these lessons learned. Namely, we'll mention the Sexual Offences Act of 2006, the Employment Act of 2007, and the Protection Against Domestic Violence Act of 2015. The goal of this work is really to provide insights for policymakers, advocacy groups, and international organizations involved in the pursuit of similar legal reforms. There are several social, political, and economic factors that created the right context for legal reforms in Kenya. We can briefly cite a few here. Increased economic growth, greater female labor force participation, and growing representation of women in parliament are all signals pointing to significant socio-economic changes in the 1990s and early 2000s in Kenya. Socioeconomic changes were reflected in the institutional and legal environment, where gender equality started to come more to the forefront. On the institutional side, after the 1992 elections, increasing attention was given to women's rights in the country, with the appointment in 1993 of a task force for the review of laws relating to women as a first significant step. The task force's recommendations and their implementation led to multiple achievements, including the establishment of the National Commission on Gender and Development in 2003, the adoption of the Sexual Offences Act in 2006, and the Employment Act of 2007. The promulgation of a new constitution in 2010 was one of the pillars that encouraged additional reforms towards more legal gender equality and increased women's political participation. It was followed by the passage of several laws, including the Protection Against Domestic Violence Act of 2015, which for the first time addressed the issue of domestic violence. Our interviews highlighted 3 key factors for the success of legal reforms in Kenya. Data and research, broad coalitions, strong legislative drafts based on internationally recognized standards. These approaches were pioneered by activists and policymakers who had learned from lessons from other reform processes and reform processes in other countries as well. So we'll touch on each one of these lessons briefly with examples from the passage of the 3 laws that I mentioned earlier. Comprehensive legislative drafts need to be evidence-based. Successful reform processes are backed by data, research, and compelling individual stories of the people that are impacted by reforms. If we look at the reforms carried out in the areas of employment and gender-based violence in Kenya, we can find some parallels. For employment, a tripartite task force appointed by the Attorney General in 2001 carried out extensive consultations to identify current issues among employers and employees. Research carried out by NGOs like the Kenya Human Rights Commission helped expose the poor working condition of women workers who were often forced to work overtime with unfair compensation and with limited protections from sexual harassment and repetitive strain injuries. And the extreme stories of women working in precarious jobs in the cut flower sector were used along with data to advocate and influence both members of parliament and members of the trade unions. All of this evidence informed the tripartite negotiations and the drafting of the 5 employment laws eventually submitted to the Attorney General in 2001, among them the Employment Act. When it comes to violence against women, data on the pervasiveness of economic costs of gender-based violence provided the evidence to call for specific protection measures to be established. In particular, following a national violence against women survey undertaken in the United States, similar studies on the prevalence and impact of gender-based violence were carried out by the Kenya National Bureau of Statistics and the National Gender Equality Commission with the support of UN Women. The preliminary results, as well as individual stories on sexual harassment and violence, were used during the advocacy efforts and also referenced during the deliberations in Parliament in support of the adoption of the Protection Against Domestic Violence Act. In this case, reforming laws by building partnerships, it is interesting to use the Protection Against Domestic Violence Act as an example of how building partnerships can allow for the adoption of a law. Broad coalitions were highlighted by many of the stakeholders interviewed as a success factor. In fact, popular support for the PADV Act, secured through the active involvement of the media and the wide dissemination of data and stories on the prevalence of gender-based violence, was key. Better coordination among civil society organizations led by the Women Empowerment Link maximize the advocacy impact by creating a united front for engagement with members of parliament. Coalitions were also crucial inside parliament to ensure that the legislation would be seen as favoring society as a whole. It was important to secure support, especially from male lawmakers. This was accomplished through an alliance between different parliamentarian associations. Finally, partnerships with donors and international organizations helped by funding research, convening activities, and supporting advocacy work helped as well. This coordinated action at several levels led many male MPs who originally opposed the bill to advocate in favor of the legislation. On March 24, 2015, the PADV, or Protection Against Domestic Violence Act, was finally passed, thanks to the tireless work done by both civil society organizations and members of parliament. Broad coalitions are only successful if they can support strong legislative drafts. Drafts are strong when they comprehensively address existing issues and contain the best practices and standards for legal reform. International organizations and donors can play an important convening role here, providing opportunities to learn from and convene around international and regional best practices. For example, the Sexual Offences Bill benefited from the engagement of civil society organizations and international organizations that supported a comparative analysis of the legislation on sexual violence in Australia, Ghana, South Africa, Tanzania, and the United States. The final draft borrowed heavily from the Sexual Offences Act of 2003 of the United Kingdom. And the Employment Act is also another example showing the importance of robust and comprehensive drafts, especially when considering its provisions on policies on equal pay and leave. An opposite example comes from the PADV Act. As adopted, the law fell short of the expectations of the original drafters and civil society organizations that supported it due to the amendments that removed important clauses and implementation provisions during the process in Parliament. Let me now hand it over to Kate to lead us through the remaining gaps in the laws and their implementation. Kate, over to you.
Thank you, Emilia. Good morning and good afternoon, everyone. Thank you for joining us. The reforms did bring about the three legislations that Emilia has taken us through, but still there are certain gaps that we needed to, or we need to continue to look into in terms of policy advocacy. Coming to the Employment Act of 2007, Section 29 of the Act gives us 90-day paid leave, maternity leave days for women, and 14 paternity leave days, but then this is not in conformity to the international guidelines or good practice as per the ILO Convention 183. And therefore, there is need to get to this minimum, or rather Kenya, to align or ratify this convention so that then we get to the minimum threshold of 98 maternity leave days. The Teacher Service Commission has gone ahead to lead in this by effecting the new particular days, in that they're looking at 120 days from the 90 provided in the law to 120 days for teachers, and also 21 paternity days from the 14 days that we have, and again 45 pre-adoptive leave days. Second, we also need to ratify or advocate for the ratification of the Convention 190 on violence and harassment, so that then we are able to recognize the right of everyone to be in a world of work that is free of violence and harassment. There is a growing need and advocacy, or rather debate, around the change in the paternity leave days here in Kenya. Kenya has among the best in the region, 14 days. But some of the countries have less, as you will see when you look at the WBL reports. Ethiopia, for instance, recently introduced 3 paternity leave days. Malawi does not have a provision, but here in Kenya, we have 14 days. Recently, earlier in the year, around January, a particular doctor, Dr. Benjamin Gikenyi, did launch a petition to change, or rather to seek the High Court to change the days, or rather to have the days changed to 3 months from the 14 days that we have now. And his argument was around that certain employees, or rather certain employers, prefer male employees compared to female employees because of the 3 months maternity leave that they're entitled to. And again, also, he felt that it was unfair to the men and denying them the opportunity, especially as fathers, to bond with their children. Again, from the WBL 2022 report, we did find that in the parenthood indicator, we scored 40.0, and this clearly shows that there's room for improvement in terms of recognizing, reducing, and redistributing unpaid care work and domestic work, so that then there's shared responsibility in the household, and we are also able to invest in social services, including childcare services and social protection policies, including childcare policies, to reduce the burden on women. Coming to the Sexual Offences Act, there are particular amendments that have been recommended, and we have had several bills or fronted, or rather amendments fronted, but then they have not been successful as yet. And one of the key things that has come up from the growing body of evidence is that there's need to create a legal regime that protects juveniles from sexual violation without victimizing these adolescents, and particularly in the Section 8 of the Sexual Offences Act, so that then we're able to include a Romeo and Juliet clause that addresses inequitable treatment between children when it comes to defilement with amongst children of under age of 18, and particularly the male children. You also appreciate that since yesterday evening, there has been a debate in the country around the minimum sentences from the High Court pronouncement by Justice Odunga around the petition that had been put by 6 men around the minimum sentences being unfair, and seeking that the courts rather have leeway to be able to, and the judges have leeway to be able to go away from the minimum sentences therein. And therefore that is a key area or emerging issue in terms of how do we then not reverse the gains that we have made from the legal reforms, but rather how do we add on to the particular gains as we revise or rather reform the laws so that they are even better. Coming to the Protection Against Domestic Violence Act, we find that again, Kenya is ahead of many other countries. We look at our neighbors, South Sudan, Somalia, Tanzania do not yet have a PADV Act, but we do have ours. And we were able to enact it with the help of many partners, as Emilia elaborated, but still the level of awareness in the community amongst ourselves of this particular act is still very low. And therefore there is need to increase efforts to raise awareness. There is also need to ensure that there's capacity building within the judiciary, prosecution officers, the police, the various stakeholders mentioned in the act, so that there's adequate enforcement and implementation of the law as stipulated even in the rules of procedure of 2020. Again, there's need also to have increased budget allocation to ensure that we have established shelters and counseling services and safe spaces. Recently, Menken had the opportunity to engage with National Gender and Equality Commission in Bungoma County, and where we were able to have conversation also amongst the technical working group there on the Dengerwa Rescue Center that is still present, but not yet serving residents of Bungoma County as they would wish. And we know also that in Nairobi County, there is a plan to have a rescue center established by the county. Now, there are various other opportunities that exist that will help us then continue to take up the lessons within this brief and ensure that we are channeling more reforms. One is the women's economic empowerment hubs that we have in our learning institution. Today we are joined by Kenyatta University. We also have University of Nairobi, and we hope that there will be more as we progress in the learning institutions. And these hubs are key in terms of ensuring that they are spurring innovations and also producing evidence that is then able to be translated into policy actions that various advocacy groups, such as the National Advocacy Coalition on Women's Economic Empowerment that is led by Action Aid, Kenya, able to continue to push for various reforms. And this data from the learning institutions can be complemented by the yearly economic surveys that give us the status reports on women's economic participation. And this data is also, we are able counties or other countries across, and this will then translate and help us to continue pushing for various legal framework changes. Currently, we do have the Women Economic Empowerment Strategy 2020-2025. We're in the third year, so to speak. And the National Advocacy Coalition is also pushing for the national policy on women economic empowerment So therefore this can be able to assist us to move forward. We know also that one of the strategic issues in this WE strategy, 4.24 to be specific, talks of women's transition from the care economy to productive economy. It also provides an elaborate monitoring framework, which the Ministry of Public Service, Gender, Senior Citizen Affairs, and special programs, together with the National Gender and Equality Commission, can then assist us in terms of monitoring the gains to do with WE. You will agree with us that the reforms are not really an end, but a means to an end, and therefore there must be meaningful implementation of this particular reform so that then we are able to get the gains. Emilia, you could just press next, thanks. So meaningful implementation means that we continue to have good practice and document good practice on women's economic empowerment. And therefore, this means that we are able to look into the good practice around work protection, around the care economy, value of unpaid care work, and so forth. Again, we are able to follow up with many other reforms that are still pending. For instance, the Micro and Small Enterprise Act of 2012 is still in the previous regime of before we got the devolution, and therefore there's need to amend it so that then it's in line with this, and we are able to utilize the lessons, the 3 lessons that you've shared here in terms of the legal reform, so that then we can reform this particular act amongst other acts. The other act that we also need to reform is enact the National Electric Single Window System Bill 2021 that was up for its second reading in the month of April so this year. And so therefore, this would then, if enacted, will be able to give those in business, and particularly women, have a particular single entry point for their import and export business, especially to do with trade and transport. And so it will also help in eliminating the particular gaps within this trade. And lastly, we need to also engender the MSME policy that we have, 2020, so that then it's in line with the strategy that we have just mentioned, but also it's able to bring out the aspects of women's economic empowerment. As it is now, it only mentions the guiding principles around inclusivity and also equality in access to opportunities for everyone, but very little is mentioned in terms of the particular objectives, and especially to do with we. So therefore, it's important to raise awareness in terms of how do we then engender the policy so that then we can work beyond mentioning persons living with disability in the cross-cutting issues. Women issues, and specifically we are targeted in the policy. I now wish to hand back over to Emilia so that then we can open up a conversation. Thank you.
Thank you, Kate. Thank you so much for walking us through the gaps in the legislation and also some next steps and opportunities. We want to open now the discussion. We've seen that evidence is one of the success factors from the legal reform process in Kenya. It is also essential to the mandate of the Women Economic Empowerment Community of Practice. And based on the gaps highlighted in this presentation, in the previous presentation, and those that you've seen from your own experience, we are curious to hear your thoughts about building more evidence to support legal reforms. We can also discuss more in detail successful strategies to share this evidence with key stakeholders, and Kate and Frederick's experience is what we can rely on. On the screen, you'll see a few questions to lead our conversations. That said, we don't have to stick to these. These are suggestions. I'll be moderating our conversation. Feel free to raise your hand, post questions in the chat, or simply unmute yourself to participate. We're a small group, so anything goes. Feel free to come in.
Hi, Amelia.
Hi, Frederick.
Yeah, I'm saying, even if it's not just someone to respond to any one of the questions, they could also seek clarification or a comment based on what has been presented, touching on the legal reforms of the three areas that we've been talking about: the Employment Act, Sexual Offences Act, and the Protection Against Domestic Violence Act. So the members, you should feel free to ask, comment, or even contribute based on what has been presented. Thank you.
Thank you, Frederick. Yes.
Hello, moderator. Hello.
Hello, Dr. Joyce.
Yes, I have two comments. I first of all want to thank you for the presentation. That was quite enlightening. However, I want to zero in on Employment Act, for example. We talked about Employment Act 2007. I don't know whether this took into consideration that there has been a bill, that is Employment Act Amendment Bill of 2021, which, as I talked to you, I'm not very sure that it has been passed by our parliament, but it has quite some reforms which need to be looked at so that as we come to conclusion, we know what's happening. The other one is the Sexual Offences Act. There is already in place a task force that is dealing with the amendment and the concerns raised on Section 8, the issue of Romeo and Juliet. As late as last week, the judiciary is looking into that with that task force, and we are sure that something positive is going to come up. Now, there is a question here: how can we ensure that laws and regulations are implemented effectively once in place? Now, that squarely lies in a mandate of the National Gender and Equality Commission, which I chair. We oversight to make sure that there is implementation. And when it doesn't happen, then we are allowed to issue advisories, or on the other hand, if not advisories, if the person or the institution does not take the advice, then we take them to court and seek legal redress. So that is what is likely to happen in Kenya. But we are alive to the fact that our Constitution 2010 is one of the richest documents. And the laws that were there before it, then that legislation needs to be aligned, not only with that particular Constitution, but also it will take cognizance of the international treaties and conventions that the country has ratified, because the same have been domesticated, nearly all of them, by what we call Article 2, Sub-Article 6 of our Constitution of Kenya 2010. Thank you. That's all I wanted to say.
Thank you. Yes, and thank you for bringing our attention to the Employment Amendment Act of 2021. It will definitely be part of the next review of our data. Every year, we look again at the laws and regulations in the countries that we study to see if there have been any reforms. So we will definitely take a very close look at the Employment Amendment Act to see if there are reforms that are changing any of our indicators. And thank you also for mentioning your work on implementation. I am actually curious to hear from you what you see or what you think are the main challenges in the implementation of some of these laws. And thank you once up for sharing in the chat the updates on the enactment of the Employment Act and the case law.
Good afternoon, Emilia. I'm wondering if you're ready for more comments.
Yes.
Okay, thank you so much. I would like to speak after my chairperson. Kuria Paul is my name, and I work for the National Gender and Equality Commission, and Kate and Nyaga are good colleagues of ours. I wanted to make an attempt to contribute to the first question. And in the recent past, we have had huge investments on women economic empowerment hubs within our universities and digital spaces, particularly targeting younger women and youth in general. And it's very clear and very possible that we can generate a lot of data from these hubs. I do know that the Kenyatta University and professor I think is in this group, and if not, maybe in a different group. There will be a conference on the same. And so there's data that will show good lessons, some of the barriers and some of the challenges that the women in economic empowerment programming would be facing, and the legal barriers that come with them can be applied and collated together to inform the process of reforming any law that is either biased or completely unenabling to women performance within the entrepreneurship, starting businesses, value additions and substitutions, and the like. So I also feel that the community of practice already established and making it stronger and reach to the informal sector and reach to the actors, particularly those in the private sector as well, would be as well useful to contribute to building stronger evidence and much more practicable evidence that can be used to reform the remaining legal barriers. Sometimes, and as Dr. Joyce, my chairperson, has said, so it's sometimes easier to pass a law in the county assembly or in the national parliament or senate, but it's sometimes completely non-implementable, completely practically difficult to implement such laws. So it's not just about having the law formulated, but the National Gender and Equality Commission ensures that it is practicable, it is non-discriminatory, it is very specific, sensitive to the gender, to the prevailing gender norms and contemporary emerging issues, because such would be required then to address a certain existing barrier or a problem or a challenge. And sometimes back, we had advocated for the review, a collation and analysis and distillation of all the judgments, decisions, declarations, pronouncements that have been made in the court of law on particular set of laws, particularly on matters they say pertaining to the gender equality or pertaining to discrimination. And put all those together and build a very strong jurisprudence that would inform the formation of future laws, able to address the gaps, because in each of those declarations or judgments or pronouncements, you're going to see the limitations. Sometimes the judges will always put the limitations and the difficulties that are in there. A good example is the non-compliance with the 2/3 gender principle, which, if you look at the judgment, it provides, the opportunities and also limitations that are in there. So an audit of such would be very, very helpful in building a strong evidence then that can be used from a practical perspective, that can be used in informing the future reforms of legislative instruments. And then lastly, I had a thought on, in addition to, on how to ensure the laws and regulations are implemented effectively. And this is a reflection onto the presentations on the broader report on the Women, Business and Law 2022. And perhaps this is a challenge to the PIs, the principal investigators, in the development of the indicators, so that we can have a lower level or a higher level. This should be a higher level of an indicator, moving away from just a law exists and looking at the provisions with that law, but also speaking to the end users, some few key informant interviews and collating some thoughts from, particularly if you look at the women in the informal sector and how that has affected their businesses, how are they affected, their childcare services that are available to them, even it is available to them, and have a measurement and construct such a measurement. Of course, that needs to go through many trials for their validity and liability. To what extent has specific provisions have been implemented over time, and whether that has changed as well, because it's about enforcement. Sometimes the implementation also goes hand in hand with enforcement and sanctions as well. And some of our laws may not have the sanctions. And where such sanctions may be there, sometimes they could be also completely discriminatory or pushing the same population that is trying to address or solve problems off to maybe even a more difficult situation. My submissions. Thanks so much and good work. And thanks to everyone and yourselves for a very clear presentation.
Thank you, Paul, and thank you again, Dr. Mutinda, for intervening earlier. Paul, you're speaking to my heart with the last points on measuring implementation. And in fact, we are exploring this area. It's very complex. It involves not just looking, of course, at the laws, it involves also looking at what are the supporting frameworks. Like you said, it's about enforcement, it's about sanctions, but not just that. Are there also policies in place that encourage or provide incentives for the private sector to implement laws themselves or respect laws? And I'm thinking here maybe about paternity leave. Are there incentives for fathers to take the available days of paternity leave? But you are really driving a point with your comment on asking women themselves about to what extent they're able to enjoy the rights that they are afforded to by law. And I think for our team, this is not possible right now, but what we are thinking about doing is ask the lawyers and legal experts on the ground that we're in touch with and that we reach out to every year to update our data about their opinion of the implementation of laws and regulations, even though they're maybe not the direct beneficiaries or women impacted by laws and regulations. They are in a good position to tell us whether the sufficient supportive frameworks have been put in place to support the implementation of the laws. For example, training of judges, police, prosecution officers on gender-based violence. And they're also in a good position to tell us their opinion about the effectiveness of these supportive frameworks. And I'm curious to hear your thoughts or the thoughts of anyone on this call. I guess we don't have much time left. There is a comment in the chat that I want to acknowledge. And yes, everyone in the financial sector should advocate for reforms that affect financial inclusion. That's also something that we are thinking about looking into more. What are specifically the supportive framework policies and strategies that support financial inclusion? I think I will see you back in the main room shortly, and we'll have a chance to continue the conversation there.
Amelia, just before you see us in the main room, I just want to put it on record that the Employment Act was actually